Well, good morning. As I say, we're talking today on the impact of fraud and illegality on professional indemnity cover in the context of claims against professionals. It's often tempting when formulating a claim against a professional to go that bit further, alleging dishonest as well as negligent conduct. There may be advantages in so doing, not least in the terms of the implications of exclusion of liability, more general limitation periods available, etc. However, while such allegations may assist in making out the claim against the insured professional, if acting for the claimant, caution should be exercised before making such allegations. Success against the professional in proceedings may be of little benefit if a professional's policy will not respond. Of course, it's right to point out that unless the insurer is a party to the proceedings, any findings made against the professional insured will bind the insurer. Moreover, the insurer is fully entitled to raise issues of dishonesty against the insured professional, even if the claimant doesn't do so in his or her claim. However, the reality is, if the claimant does raise such allegations against the insured professional, it is far more likely that those allegations will be relied upon by the insurer than if such allegations are not made. And if the insurer declines cover and is made a party to the proceedings, it will of course be entitled to rely on any findings made on the claim. I shall return to this theme at the conclusion of our talk. In our session today, we shall address the issues of illegality and fraud in the context of claims against professionals. While insurance policies may be unenforceable because the policy was illegal as to formation or performance, or the insured may lack an insurable interest because of illegality. For example, a thief has no insurable interest in goods he has stolen, of course. Typically, in the context of claims against professionals, illegality and fraud arise because the act giving rise to the liability will involve the insured or an employee committing an illegal act which has caused loss to the professional's client. Wherever the policy will provide a liability or an indemnity in such an eventuality will turn on the true construction of a policy and questions of public policy. Today I shall first address questions of construction of a policy wording, condonation, and cover-ups, and Aidan will then address you on the role of public policy and D&O policies. We're addressing matters in that order for a particular reason, and that's because in determining whether an insured or claimant is entitled to an indemnity, the first question will always be whether upon a true construction of the policy wording, both the provisions in respect of cover and exclusions, the insurer is liable to indemnify the insured. It is only if, upon a true construction of a policy, the insurer is liable, will questions of public policy arise. The question then being whether, notwithstanding the presumptive entitlement to an indemnity, that entitlement ought to be denied as a matter of public policy. So let's turn to some basic principles concerning construction of insurance policies in this context. In determining whether the insured professional is entitled to an indemnity, the first question will inevitably be whether, on a true construction of a policy, that policy provides for an indemnity for liability arising from a particular conduct in question. Both the cover clause and any relevant exclusions have to be construed. The principles applicable to the construction of all insurance policies were recently summarized by the Supreme Court in the well-known case of Financial Conduct Authority and Arch, in which they referred back to the detailed consideration of the applicable principles in the divisional court. Any decision on the construction of particular policy wording must always be treated with a note of caution, because obviously it's the particular wording that needs to be construed. However, there are some principles of general application in this context that can be stated. For example, an insuring clause that provides cover in respect of negligence of the insured will not provide an indemnity in the event that the claim arises out of deliberate or fraudulent conduct, even if the conduct could be classified as mixed negligence and fraud. And that was decided in the case of West, Wake, Price and Ching. In that case, the policy wording provided cover for any claim that might be made against the assured in respect of any neglect, default, or error arising out of their conduct of business as accountants. A clerk employed by the accountancy firm insured received monies from two clients, which couldn't be accounted for. The accountant's clients sued the insured. Their claims against the insured were formulated in three ways: damages for breach of duty, that is negligence, monies had been received, and conversion of the monies. The accountants claimed an indemnity from their PI insurers, but it was held that the client's claims were primarily in fraud, and that the policy only provided cover for negligence alone, not cases of mixed negligence and fraud. And on that basis, the insured wasn't entitled to an indemnity under its PI policy. Moreover, there is a more general and perhaps fundamental principle of construction that comes into play. That principle finds statutory expression in Section 55(2) of the Marine Insurance Act 1906, which applies to non-marine insurance as well, and provides that the insurer is not liable for any loss attributable to willful misconduct of the assured, but, unless the policy otherwise provides, he is liable for any loss proximately caused by a peril insured against, even though the loss would not have happened but for the misconduct or negligence of the master or crew, i.e. employees. As Lord Atkin authoritatively stated in Beresford and Royal Insurance Company Limited, absent any contrary provision, on ordinary principles of insurance law, an assured cannot, by his own deliberate act, cause the event against which the insurance money is payable. The insurers have not agreed to pay on that happening. The fire assured cannot recover if he intentionally burns down his house, nor the marine assured if he scuttles his ship, nor the life assured if he deliberately ends his own life. This is not the result of public policy, but of the correct construction of the contract. The strictness of this initial principle is rather relaxed by various matters. In the context of professional liability, as the slide says, it's almost always the case that professional liability insurance policy will be designed to respond to a tortious act. And the courts recognized that in analysing such policies, the ultimate beneficiary is the third party who suffered the loss, rather than the insured. So on that basis, professional liability insurance is therefore intended to respond to tortious acts, even when those acts or omissions are deliberate. Indeed, as a matter of strict construction, the strict principle is always subject to the express wording of the policy. Returning to the facts of Beresford, in that case, the policy did in fact specifically provide for the event of suicide by the insured, and it was held that on true construction of that provision, the insurer was liable to pay to the executors or assigns of the assured the sum insured if the assured committed suicide after 1 year from the inception of a policy. However, at the time of the case, suicide was a criminal act, and it was held that as a matter of public policy, the policy wasn't enforceable. Beresford's a useful authority because it highlights both the importance of the precise wording of the policy, but also the interplay between construction and public policy. If the policy on its true construction provides cover, then there is a role for public policy to deny liability under the policy. So let's turn to the position of insured and employees. Policies typically particularly exclude cover for fraud and dishonesty by the insured. However, that begs the question, who is the assured? And in particular, will the conduct of an employee be regarded as that of the insured for these purposes? The issue arose clearly in a personal injury case, the case of Hawley and Luminar Leisure Limited. In that case, the first defendant, Luminar, operated a number of nightclubs, including one at Southend. It engaged ASE, the second defendant, to provide doormen. W was employed by ASE, and he was provided to Luminar as a doorman. He worked at the Southend Club for 2 years. One night, in the course of his work, he punched the claimant, causing serious, indeed life-changing injuries, which W was convicted of assault, occasionally grievous bodily harm. ASE went into his insolvent liquidation, but had the benefit of a PL policy, public liability policy. Claimant sued both ASE and Luminar. ASE's insurer declined to indemnify ASE as the policy covered liability only arising from accidental bodily injury, and the insurer said that deliberate infliction of injury by W did not amount to such, and indeed that might seem to be almost axiomatic. The claimant sought a declaration that he could recover under the terms of the policy. The underwriter was added as a party to the claim as third defendant. Default judgment was entered against ASE for an amount to be assessed, and one of the issues of the trial was whether the liability attaching to ASE by reason of the judgment was to be regarded as a liability for accidental bodily injury within the meaning of a policy wording. The judge found that W had deliberately punched the claimant, intending to do him serious harm, but that the injury was accidental within the meaning of a policy. He therefore made a declaration that the insurers were liable to indemnify ASE, that they were liable to pay the claimant any damage and costs against ASE under the Third Parties Rights Against Insurers Act 1930. The appeal was dismissed. The Court of Appeal held that the question of whether injury caused to the claimant was accidental or its synonym, fortuitous, had to be judged from the perspective of the insured ASE, not that of the individual perpetrator, W, or indeed the victim, the claimant. The question that arose, therefore, was whether the state of mind of W was to be attributed to ASE, whether, as the judge held, ASE and W were to be treated as separate from the perspective of a policy. It was held that the intentionality and conduct of W ought not to be attributed to ASE, although, of course, ASE were vicariously liable. Or that's an issue which we've gone into in some detail on the facts of the case. We don't need to deal with that today. It follows in the absence of an applicable express exclusion in the policy, extending expressly to the conduct of employees for whom the insured is only vicariously liable. Generally, where the illegal conduct is that of an employee, the question of cover will turn upon whether the act in question can properly be attributed to the insured, so the act is that of the insured for the purposes of the policy. Attribution will turn on the closeness of the relevant act or decision to the partners, board, or members of the insured. In Hawley, the court postulated a hypothetical situation in which the decision had been taken by the board of ASE for all the doormen whom they sent out would take a particularly aggressive approach toward troublesome or recalcitrant members of the public, in which event the attack might not be regarded as accidental from the perspective of the board. It may also turn the role being performed by the relevant partner, director, or member. That issue arose again in another non-professional negligence case, professional conduct case, KR and Royal Insurance, the Royal Alliance plc. The question of attribution arose in that case in the context of physical and sexual abuse perpetrated in various care homes operated by the defendant insured. The policy of insurance contained an exception whereby liability under the policy was excluded for injury resulting from any deliberate act or omission of the insured. From 1981, that exclusion was widened so as to extend to the insured's partners, directors, and managerial employees. A number of former residents sued the insured. Judgment was entered in all but one case on the basis of systemic negligence in the operation of the homes by the insured. The insured went into liquidation, and 6 claimants commenced proceedings under the 1930 Third Parties Rights Against Insurers Act. It was held at first instance that the claimants' claims had succeeded on the basis of negligence, and that the acts of abusers were not to be attributed to the company, not even the act of a managing director. Therefore, the exception didn't apply, even after the same had been widened. It was not the status of the abuser, but rather his role. In each case, the employee, no matter how senior, was not acting in a managerial capacity, but for, as they were characterized, his own selfish ends. So that was the decision at first instance. On appeal, however, it was held that the exclusion was intended to exclude liability for the deliberate acts or omissions of any person to be equated with the company, the insured. It was not confined to acts done in the course of the operation or management of the company. It followed that the acts of abuse suffered by individual claimants came within the exception clause if the abuser were to be treated for these purposes as the company. And on that basis, the claimants weren't entitled to indemnity in respect to the acts of the managing director throughout, or in respect of those were principals of the homes after the 1981 wording, whether no other employees were to be treated as the company within the meaning of the exception clause. Jackson and Powell on professional liability, 9th edition at paragraph 8104, prefer the analysis of the judge rather than the Court of Appeal, and doubt whether the Court of Appeal's analysis can withstand the recent analysis of attribution in the Supreme Court, in cases such as Bilter and Nazir. But to date, the decision in KR and Royal Sun Alliance has not been overruled, and the decision in Bilter is clearly distinguishable. Given the decision in Bilter, the key question might be framed in this way. Might it be right to attribute the wrongdoer's conduct to the company for the purposes of the claimant's claim against the company, but deny such attribution in the company's claim against insurer? So moving on to the issue of condonation. Many professions insist that their members have PI cover with minimum terms. So chartered accountants, for example, are subject to the ICAEW's PII regulations, which prescribe minimum wording for liability insurance, in audit, insolvency, probate, and investment business. And under that minimum wording, cover is provided, save by the exclusion in E8, which excludes cover for any claim if the insured is seeking an indemnity of a claim and he has committed or condoned, or it has committed or condoned, any dishonest or fraudulent act or omission that's material to the amounts payable as a result of such claim, provided the exclusion does not take effect unless and until such insured admits to insurers that the insured did commit or condone such dishonest or fraudulent act or omission, or a final and unappealable judgment has been determined per se. The current wording applicable to insurers under the SRA Indemnity Insurance Indemnity Rules 2013 provides similar cover. Both the FRA rules and the ICAEW rules and refer to acts committed or condoned by the insured. Commission would generally turn, as we say, upon attribution, but let me turn to the issue of condonation and look at a couple of cases in which the issue failed to be considered. The first case is Zurich Professional Limited and Kareem, in which the claimant insurers sought declarations that the claims that arose under the relevant policy of insurance arose from dishonesty or fraudulent acts or omissions committed or condoned by the insured, so that the insurers weren't obliged to indemnify the insured in respect of their claims. Mr. Justice Irwin held that the phrase dishonesty or a fraudulent act or omission committed or condoned is intended to be disjunctive as between dishonesty and a fraudulent act or omission, and on that basis, condonation of persistent dishonest handling of client money breaches of the solicitor's rules and so forth was sufficient to entitle the insurer to reject liability to all of the insureds, not just against that solicitor who committed the relevant fraudulent acts. However, that case now needs to be read, subject to that case which I now turn, which is the case of Axis Specialty Europe SE and Discovery Land, in which the Court of Appeal gave consideration to a policy which was intended to comply with the 2013 version of the amendment wording under the Solicitor's Indemnity Rules. It provided cover in respect of any claims, directly or indirectly, arising out of or in any way involving dishonest or fraudulent acts, errors, or omissions committed or condoned by the insured, provided that no dishonest or fraudulent act, error, or omission shall be imputed to a body corporate unless it was committed or condoned by, in the case of a company, all directors of that company, or in the case of an LLP, all members of that LLP. In Axis, the insured indemnities were Gyre House Partners LLP, Gyre House, an unlimited company, and Gyre House Trustees Limited, which collectively were referred to as the Gyre House entities. Each of those entities had two members or directors. One of them, a Mr. Jones, misappropriated monies amounting to a sum in excess of £9.3 million belonging to the claimant, and those monies were to be used in connection with the purchase of a Scottish castle. Mr. Jones also caused the castle to be used as security for a loan in the sum of one of the claimants for a sum in approximately £5 million, without that party's authority, which was ultimately paid out to another company owned or controlled by Mr. Jones, separate from the Gyre House entities. Most of that sum was dissipated by Mr. Jones, although some of it was ultimately returned back to the claimants. Ultimately, Mr. Jones confessed his conduct to the other director and member, Mr. Prentice, who immediately tendered his resignation. The claimants commenced proceedings against each of the Gyre House entities and obtained judgment in default. The Gyre House entities became insolvent, and a claim was made against the insurer under Section 1 of the 1930 Act, 2010 Act this time. One of the issues that arose of the trial was whether the other member or director, Mr. Prentice, condoned Mr. Jones's dishonest behaviour that gave rise to the claims under the policy, so as to entitle the insurer to rely upon the exclusion for dishonest and fraudulent acts. You'll recall that in that particular policy, it was acts of each and every one of the directors that had to were relevant for purposes of acting and condoning. So at first instance, Mr. Justice Knowles found that he had not. The insurer appealed. The appeal was dismissed on its facts. While findings of dishonesty were made against Mr. Prentice, it was held that his dishonesty concerned attempts to distance himself from Mr. Jones' activities, rather than because he had not had any knowledge of Mr. Jones' misappropriation, and there was no causal connection between the conduct condoned and the loss. In the early substantive judgment of the court, Lady Justice Andrews made a number of observations of general application. She held that the policy had to be interpreted in line with the principal purpose of insurance cover against professional liability, namely the protection of the public, but makes use of the service of solicitors. She relied in that respect on the decision of Impact Funding Solutions Limited and Barrington Support Services, a decision of the Supreme Court in 2016. So under direct consideration, she held, the policy terms, including any exclusions, were to be construed neutrally. The exclusion, she held, secondly, was aimed at the situation in which there was complicity by all the members or directors of the insured entity in the fraud or dishonesty of one or some of that number, such that it was appropriate to treat the entity itself as having acted fraudulently or otherwise dishonestly. It therefore reflected a fundamental principle of insurance law that a person cannot insure themselves against the consequences of their own dishonesty. Condemnation in that context was inconsistent with innocence. As a matter of ordinary English, to condone meant to treat as acceptable conduct that was unlawful or morally blameworthy. To condone conveyed acceptance or approval, and it didn't require an overt act, but rather might take place silently and by conduct. On a proper construction of the exclusion, there had to be a causal nexus between the dishonest behaviour said to have been condoned and the claim against the insured for which they sought an indemnity under the policy. It was the condemnation of that particular dishonest behaviour which led to it being attributed to the insured entity for the purpose of Clause 2.8. Excuse me. Therefore, if Mr. Prentice had condoned the misappropriation, or indeed the loan, although that wasn't part of the insurer's case, then the insurers would have been entitled to rely upon Clause 2.8. The language of Clause 2.8 was wide enough, however, to embrace a situation in which someone condoned a pattern of dishonest behaviour that was of the same type as the dishonest behaviour that gave rise to the claim, and of which the latter formed a part. Take an example in which one member director condoned the regular use by the other member director of client funds for their own purposes, irrespective of whether he was unaware of the specific instances of such behaviour that gave rise to the claim or claims. For example, because the potentially condoning director or member was on holiday at the relevant time. The question in each case would be whether or not knowledge and acceptance or approval of other acts in the same pattern amounted to condonation of the act or acts that gave rise to the claim. In each case, it would be a matter of fact and degree as to whether condonation of certain acts amounted to condonation of others. She also held that one cannot condone dishonest behaviour and have some knowledge or awareness of it. That doesn't necessarily mean that the condoner must know of a fraud or of a dishonest act before or at the time it was committed. If he does and fails to do anything about it, he might be more appositely described as an accessory to the other person's dishonesty, and thus as a party rather than a condoner. But a person might condone another's dishonest behaviour after the event by doing or saying something, such as assisting to cover it up or lying about it to others, or by not taking the type of action that one would expect an honest person in that position to take. If a person has a duty to act on becoming aware of a behaviour in question and fails to do so, we're more likely to be found to have condoned it than someone who has no such duty. So the SRA wording, or indeed the ICAEW wording, will therefore cover liability arising out of dishonest or fraudulent conduct for which the insured is liable, unless such conduct is committed, including a conduct attributed to it, or condoned by each member director of the insured, and in the case of condonation, there has to be a causal nexus between the conduct condoned and the facts giving rise to the claim. So, finally, by me at this stage at least, covering up the error. Closely related to the issue of condonation is the, quote, cover-up, close quote. In each case, the conduct occurs following a wrongful act. Take an employee of the insured who negligently or even dishonestly causes loss to a client. The principal of the insured discovers that conduct and takes steps to conceal the negligence or dishonest conduct, for example, by assuring the client that all is well. So, one example which occurred in my own practice was the case of Holstall and Champion Consulting, in which I acted for claimants against a negligent firm of accountants who gave misleading tax avoidance advice. Parties claimants entered into a tax avoidance scheme. Years later, HMRC start opening inquiries, and the negligent accountants assured the clients that there was nothing to worry about. That's a type of cover-up. But in that case, no particular issue arose as to the insurer's entitlement to an indemnity. But suppose the cover-up was fraudulent, and the insurer relies upon the same as a defence to a claim for an indemnity, how might the courts respond? The critical issue will be whether the operative breach giving rise to the loss is the original negligent act or the subsequent fraudulent cover-up. There are three ways in which the issue might be considered. So, just to be clear, this is the case in which there's negligence at the outset but a fraudulent cover-up. So the court might first treat the original negligence and the cover-up as being entirely separate. Depending on the facts, the client might rely upon either as being a breach that gives rise to the claim for loss. If they rely upon the negligence, no question of condemnation would arise, and the policy ought to respond because there would be no causal nexus between the events giving rise to the claim and any dishonest cover-up. Second, the client might seek to rely upon the fraudulent cover-up as the basis for the claim. We might do so, for example, on the basis that the cover-up prevented the consequences of the original conduct being corrected, and the claim arising out of the cover-up could be brought within the applicable limitation period, although, of course, Section 32(1)(b) might be available in relation to the original conduct. If the cover-up were the operative breach, the insurer would probably have a defence to a claim for an indemnity because of an exclusion of public policy on the basis that the cover-up involved fraud and or dishonesty. So thirdly, the insurers might be able to frame the cover-up as being part and parcel of the series of events giving rise to the loss, so that the subsequent fraudulent cover-up taints the entirety of the conduct, including the original negligent act. In that event, at least where the cover-up was committed, attributed to, or condoned by the insured, the insurer ought to be able to rely upon the exclusion of a policy, or alternatively public policy, as a defence to a claim for an indemnity. At least where the original wrongdoing involved dishonesty by a third party, the cover-up may well, in any event, constitute condonation. A good example is the case of Manolakaki and Konstantinides, in which the judge held that the insured was liable to his client for breach of fiduciary duty and negligence in respect of advice given to the client to invest in a fraudulent investment scheme, as to which fraud the insured had turned a blind eye, but had subsequently engaged in a fraudulent attempt to cover up that conduct by withholding documents and providing evasive and dishonest acts as answers to questions raised by the claimant's subsequent solicitors. The latter conduct was part of a cover-up, but equally demonstrated a condonation of a fraud perpetrated by the third-party fraudster who operated the investment scheme. So that deals very briefly with issues of construction, condonation, and cover-up. I shall now hand over to Aidan, who will address you on the role of public policy in this context. Thank you.
Thank you very much, Andrew. To understand the role of public policy, which has been referred to a number of times in the authorities that Andrew mentioned, we first have to think about the way it operates in a traditional insurance contract, distinct from liability insurance. And you heard earlier on about one of the extracts from Lord Atkin's judgment in Beresford in the House of Lords, where he talked about marine insurance contracts, fire insurance contracts, or life insurance contracts. So those were the examples that he referred to. And in those instances, what the assured is traditionally doing is insuring against the happening of an event or sets of events. In that context, once one has addressed one's mind to the question of what the contract means, what the indemnity covers, one then turns to the question of whether the obligation of indemnity is enforceable in light of the occurrence of an illegality. And indeed, this is something which, as the House of Lords recognised in Beresford, that the court can look at, even on its own volition. Now, where the illegality in question is the act of a third party, we have no concerns because the assured is a stranger to that action. But where the act of illegality is some act of the assured, and where the act is causal of the loss otherwise indemnified, the question we have to ask is whether the illegality should operate as a a bar to the recovery under the policy of insurance. And you can get quite unusual distinctions, or at least historically you could. So in Beresford, the House of Lords considered just such a question. In that case, as Andrew noted, the assured had killed himself. Now, it was found as a matter of fact that the reason he had done this was because he was insolvent, and he killed himself in the hope that his creditors would benefit from policies of insurance that he had taken out some time earlier on his life. Those policies expressly covered what the House of Lords at that time referred to as sane suicide after the first 12 months of the inception of the policy. Now, again, as Andrew noted, at the time, under common law, suicide was unlawful. And so the House of Lords held that, notwithstanding that the policy expressly covered what they referred to as sane suicide, it was not enforceable for reasons of public policy. And Lord Atkin, giving his speech to the House, contrasted this with other scenarios in which the deceased might not be the beneficiary of the policy of insurance. And so the House expressly noted that there was nothing to stop a lender from insuring against, again, what they referred to as the sane suicide of a debtor. And also, in the event of an assignment of the benefit of the policy by an assured, the assignee could also enforce the policy. So if the deceased had assigned the benefit of the policy prior to his death, it could have been enforced by those third parties. The reason why public policy barred recovery in this case, and in the other cases in which it does, is that it's an application of the maxim extirpe causa non oritur actio. And this meant that in a traditional policy of insurance, an assured could not recover for its own illegal action. If the conduct which brought about the loss was itself unlawful, this would prevent your recovery. And this principle, which applies cross-contract law, was traditionally applied in quite a rigid manner, with the House of Lords in Tinsley and Milligan back in 1994 setting out that the touchstone for this really was that a party would be barred from claiming relief if they had to plead their own illegal conduct. But the principle has been much reformed of late, and this reform was probably overdue because the rigidity of the principle, which was supposed to provide certainty, had been undermined in its efficacy and in its coherence as a result of numerous exceptions to it and carve-outs, which really had made it something of a partial jigsaw, so that, for example, if it could be proved that the intended illegality had been resiled from sufficiently in advance, this could allow a party to rely upon their previous illegal intentions. In Patel and Mirza, the Supreme Court reconsidered the principle and it changed the formulation in a fairly radical manner. So, Patel and Mirza was a claim in unjust enrichment. The claimant had paid the sum of £620,000 to the defendant with a view to making a bet on RBS's share price based on insider knowledge. Now, this agreement itself amounted to a conspiracy to commit the offence of insider dealing, contrary to Section 52 of the Criminal Justice Act of 1993. In the event, the bet never goes ahead, and the claimant then asks for his money back from the defendant, but the defendant doesn't pay it to him, and so this leads to him bringing a claim. But to bring his claim, he has to explain why the consideration for the payment to the defendant had failed. And applying the traditional approach, the courts at first instance and in the Court of Appeal held that the claimant couldn't succeed because he had to plead and rely upon his own illegal conduct. However, when the case got to the Supreme Court reversed those decisions. And in doing so, the Supreme Court adopted a less rigid approach to illegality. So instead of an apparently hard and fast line of saying you cannot rely upon your own illegal conduct, so if you have to plead it, you will fail, the court endorsed a more nuanced approach to illegality in which one looks at whether allowing the claim would be harmful to the integrity of the legal system. And this assessment, in turn, involves an analysis of the particular illegal conduct in question. So the court must look, when assessing the role of public policy, at what the purpose of the prohibition is. And it must ask whether denying the claim would enhance that purpose. It must also look at whether, the other side of the coin, whether denying the claim would have an impact on another relevant public policy. And the court must ask whether denying the claim would be proportionate, a proportionate response to the illegality. This represented quite a significant doctrinal shift in how we understood illegality, such that instead of having really a very clear rule where the starting point was that one couldn't plead on and rely upon one's own illegal conduct, we now have a balancing exercise as to whether in any given case the reliance upon one's own illegal conduct should operate as a bar to recovery. Now, this might have been expected to bring about a fairly radical shift in how the law dealt with these things. But actually, the impact has been more limited than what might have been expected. And the reason for this, I think, can be seen in part in the Supreme Court's more recent decision in Henderson and Dorset Healthcare University NHS Foundation Trust, where the Supreme Court held that the pre-Patel authorities on illegality remained of precedential value unless it could be shown that they were not compatible with the approach set out in Patel, in the sense that they could not stand coherently with the reasoning in Patel or were wrongly decided in light of that reasoning. Lord Hamblin summed it up by saying that does not mean that Patel represents zero, and that in all future illegality cases it is Patel and only Patel that is to be considered and applied. That would be to regard, he said, the value of precedent built up in various areas of the law to address particular factual situations giving rise to the illegality defence. Those decisions remain of precedential value unless it can be shown that they are not compatible with the approach set out in Patel, in the sense that they cannot stand with the reasoning in Patel or wrongly decided in light of that reasoning. Lord Toulson, Justice of the Supreme Court, made it clear, Lord Hamblin said, in Patel, that the principles he had identified supporting the majority reasoning were to be found within the existing case law. So this means that whilst any question of illegality and its impact on the insurance cover must be approached in light of the reform test in Patel, existing authorities will continue to be followed unless they cannot stand consistently with the Patel reasoning. And so, as litigators, we should not assume that when faced with an issue of illegality, the existing cases are a guide to what will happen, but rather we've got to, and we're automatically followed, but actually what we've got to do is we've got to look at their reasoning and say, can this survive? Can this stand? Is this outcome consistent with what was decided in Patel? If it's not, then you're going to have an argument in favour of departing from that existing case law. If it is, however, it's going to be quite a strong reason for the court to stick with the pre-Patel authority and what it determined. The other thing I'm going to talk about very briefly is directors and officers' policies, because I think it's a useful thing to be aware of as commercial litigators, in addition to the general rules concerning professional liability insurance. So these policies are, in a manner, akin to professional liability policies, policies which are specifically designed to provide cover in respect of wrongdoing. And the ability of a company to take these policies out is something which is envisaged by Section 232, subsection 2, paragraph A, and Section 233 of the Companies Act 2006, where a company is specifically authorised to be able to purchase and maintain for a director insurance against liability for negligence, default, breach of duty, or breach of trust. Now, these type of policies are often described as consisting of multiple sides. Usual policy will have one side which covers the company and one side which covers the director, and the policies will usually respond to claims brought for wrongful acts, which will encompass, for example, breach of duty, breach of trust, error, misstatement, misleading statement, and breach of warrant of authority. Contract claims are regarded as excluded unless the policy specifically provides otherwise. The wording of any given policy will be important. And so if you're advising on these sorts of policies and the type of cover that they are offering, you have to be very alert to differences in wording between them. But in general, the policies will not cover deliberate or reckless conduct by the director that has caused loss. The policies will also not generally compensate directors where they are forced to disgorge profits made in breach of fiduciary duty. And criminal conduct may operate to prevent recovery under the policies. A third side is available to some policies which may respond to specific criminality and fines levied. And also, more generally, following Patel and Mirza, when one's talking about criminal conduct and whether it operates as a bar to recovery or an indemnity under the policy, this will depend on the purpose of the prohibition which has been breached by the director and the proportionality of the response in denying recovery. The contract of insurance might also provide for other exclusions. So a common enough one is that one might see that where a director is himself a shareholder and he would benefit from recovery by the company under the policy for unlawful conduct of his own, the policy may well exclude this. The policy might also exclude recovery for exemplary damages. The policies therefore need to be carefully considered when they're taken out and where claims are made upon them. I'm just going to hand back to Andrew now, who's going to give you a few tips for the third party and final thoughts.
Thank you very much indeed, Aidan, for that. So today we've approached the question of how the courts deal with the issue of indemnities for professionals in terms of both construction and public policy. We've outlined the manner in which the courts will follow construction and also how they will outline and deal with issues of, public policy. When I began this talk, I dealt with the issue of what I might call Pyrrhic victories. It's very tempting when formulating a claim against a professional to use every single conceivable argument. If there's a claim in deceit or work, throw it in. It's got advantages because you will have you won't be able to exclude liability, the consequences of fraud. You get a more generous limitation period under Section 32(1)(a) of the Limitation Act. The rules of remoteness don't apply in the same way. So there's all sorts of tactical reasons why you might want to add a claim in fraud in addition to a claim for professional negligence. And really, what I think I'd like to conclude this talk by is just reminding you all, whilst there are clear benefits in adopting that course, there are also some very real disadvantages, because if you raise an argument of fraud against a professional, you are highlighting in words of one syllable to professional indemnity insurer that there may be an issue of fraud, there may be a way of avoiding cover, and it's all well and good succeeding against a professional, but if you end up with a judgment of ultimately you cannot enforce, then it may well be a Pyrrhic victory. And so I suppose the way I would conclude is by saying this: there may be cases in which tactically you need to rely on fraud. You may need to be able to rely upon Section 32(1)(a) of the Limitation Act. You may need to avoid an exclusion clause. You may need to avoid rules on remoteness. You may wish to rely upon the presumption of inducement. So there's all sorts of tactical reasons why you might have to rely upon fraud. But do at least pause for thought. Only use fraud when you need to, because you may end up with a judgment against a professional, but ultimately cannot be enforced. So thank you all very much indeed for listening. I hope that's been some benefit to you all, and thank you, and we'll look forward to seeing you again shortly in our next series of seminars. Thank you very much indeed, and thank you, Aidan.
Thank you.